Hi class, it's Mr. Stewart, and I'm back this week for another integrity video. I thought last week's chapter was straightforward enough that we didn't really need integrity video. If you read the chapter, you shouldn't have any problem digesting that material. This week, chapter 8, we're going to be talking about the trial courts as an arm of the criminal justice system. And there's a few things I'm going to talk about today. This probably won't be a very long video and won't go into a lot of detail because, honestly, the trial courts are also pretty straightforward and fairly simple. One of the things I want you to understand is that each state, as well as Washington, D.C., has their own version of the trial courts. So we have 51 different types of trial courts here in the United States, not counting the federal trial courts. So if we lump the federal trial courts into that, 52 different types. And they all have a little bit different names, some different procedures, but as a general rule, the trial court is where the accused goes to trial and we make a determination either through a bench trial with a judge being the decider of fact, or through a jury trial with the jury being the decider of fact, whether or not that defendant is guilty of the crime that they have been charged with. So there are some steps that a defendant goes through when they enter the criminal justice system. Of course, when you get arrested, we would call that a police contact, and you get taken to jail. And typically at jail, depending upon the seriousness of the offense, you may or may not be allowed to bond out of jail. At some point, if you are not allowed to bond out of jail, or you can't make your bond, due to either it being set very high and you just don't have the ability, the resources to make that bond, or the judge decides that no bond should be set because of the seriousness of the offense, you have to go to court and be seen by the judge, and that's something called an initial appearance, and that's typically the first encounter with the courts and the judicial process. At the initial appearance, the judge actually formally advises the defendant what they've been charged with. In many cases, they will tell them exactly what the potential punishment if they're found guilty of. They will ascertain whether or not they want to hire a lawyer, the defendant wants to hire a lawyer, or whether they need one appointed for them. And then they may, in many cases at that point, set a trial date. And that trial date could be anywhere from 2 weeks in a very mundane or less serious case, all the way up to it could be several years before we actually set a real trial date because of the complexity of the case. Like in a murder case, it may take a year, 2 or 3 or 4 or 5 even for a case to make it to trial. I testified in federal court in 2009 on a case that I made in 1993. That's when they got around to trying this defendant. From 1993 to 2009. That is a long time, guys. That's a long time. That's the exception to the rule. Most of the time, these trials are commenced fairly quickly, unless the case is just very, very serious and very complex. So, the initial appearance, the judge also looks at whether or not bail might need to be reduced, or what bail should be set at if the magistrate did not allow the defendant to bond out after the arrest. They may even have a hearing if there's conflict on whether or not between the prosecution and the defense as to whether bail should be set or how much it should be set at. So there's several things that happen during this initial appearance, but it is a constitutional requirement that typically within 72 hours of your arrest, you are brought before a judge but for that initial appearance so that you are formally advised of the charges. That's really the sole purpose of the initial appearance is the formal advisement of charges. However, we also take care of a lot of other business, and even in many courts for less serious offenses, we also see that they will even accept a plea and go ahead and dispose of the case at that very first appearance. We're seeing less and less of that these days, but we used to see a lot of it when I was first in police work in the 90s. So, with that being said, the initial appearance is the first step in the judicial process. And understand we also have two sides, and this should go without saying, but just to make sure that you understand, we have the prosecution and the defense. The prosecution represents the state and or the victims of the crime, and the prosecution is a government attorney. They are paid by taxpayer money in order to prosecute that defendant for the law violation. The defense, in turn, represents the defendant. And in many cases, they are a privately paid attorney, which means the defendant pays the attorney or their family pays the attorney to offer them a zealous defense. If you cannot afford to pay for an attorney, one can and will be appointed for you at little or no cost. And in those cases, taxpayer money also pays for the defense. There is a belief out there that the public defenders or the appointed defense attorneys do a much worse job at defending their clients than those that are privately paid attorneys, and there is some truth to that. I mean, typically your public defenders or your taxpayer-funded defense attorneys are underpaid, overworked, they have a high caseload, and they just cannot put forth enough effort and time into each individual case where a private attorney may only have 2 or 3 cases at once, whereas a publicly paid attorney may have 100 cases at once. So I think you can see the issues with that. So the prosecution is usually manned by the district attorney, which is elected, or one of the elected district attorneys' assistants or deputy district attorneys, which are typically appointed by the elected district attorney. Again, they're taxpayer funded. Please read the section 232, 233, and 4 about how we go about filing charges. There's a couple different ways. A police officer, if they catch somebody engaging in a crime, they have the ability to arrest them, file charges immediately, send that through the court system. However, with many investigations, we don't necessarily catch somebody in the act. We simply investigate it and find that this person engaged in this crime. So then we take it to the grand jury. And the grand jury is an independent investigative body made up of citizens. And the officer presents, or the investigator presents their case. That's the only side they hear is the officer's case. The grand jury determines if there's probable cause that this person should be arrested and tried for that particular crime. And if they believe that probable cause exists, they will issue something called a true bill. And that basically is an order to go arrest that defendant and then to instruct the trial judge to try this defendant for this particular crime. If the officer doesn't make his case with enough probable cause, then the grand jury can return a no true bill, which means we're not going to arrest them, we're not going to try them for that particular crime. So that's how charges typically are filed against a defendant. Either the police officer files them directly after an arrest, or they go through the grand jury, which is again the independent investigative body, and they do their work in secret, by the way. Their discussions and their votes are all done in secret, and nobody knows how they vote. I can tell you that in many places the grand jury has to be unanimous in their decision. In some places it simply has to be a majority of the vote, but in most places it's a unanimous decision by the grand jury that every person who sits on that grand jury must vote to indict that defendant before they would be charged and arrested and charged for whatever the offense that the officer presented to them. On 236, it starts talking about something called the exclusionary rule. I want to make sure that you read that very closely, because what the exclusionary rule suggests is that if police officers engage in an illegal search, and during the course of that illegal search they find good evidence that they could use against somebody, the court will not allow that good evidence to be admissible and be used against that defendant because the search itself was illegal. So that evidence is excluded from trial. Now, there's some exceptions to the exclusionary rule, but as a general rule, the police must engage in lawful and ethical searches before evidence obtained through that search could be used at trial. So make sure you read that section. On 237, it also talks about confessions, and that's where we get into something called the Miranda warning. If we have a suspect in custody and we want them to basically tell us that they were involved or they were complicit in the crime, by law, after a 1966 court decision called Miranda versus Arizona, we have to advise them that they have the right to remain silent. Anything they say could be used against them. They have the right to have an attorney present with them during questioning. They have the right to stop answering questions at any time. If they can't afford an attorney, one would be appointed for them, etc., etc. And that was based on a decision where a guy named Miranda, who was very guilty of the crime that he was arrested for, he was unmercilessly interrogated by the police for an extremely long amount of time. He wasn't allowed to go to the bathroom, wasn't allowed to get something to drink or eat, and he finally confessed to the crime to stop the interrogation. And the court looked at that as coercion. They said, it doesn't matter whether he did it or not, you can't make them confess through force, is really what happened. So even though Miranda actually had committed the crime, and it was a pretty heinous crime, he actually was let go because the police elicited a confession out of him through force and coercion. Now, the interesting part was Miranda actually walked into a bar some years later and was killed because of mistaken identity. So I guess karma does have a way of coming around and getting you. He needed to have been in prison for the crime that he was let go on by the court. But that's a court decision that has stuck with us for many years, and that's something that's become a standard part of police procedure at this point. Is before we can get somebody to confess to a crime, we have to advise them what their rights are. Now, if somebody simply has diarrhea of the mouth and they blab to you without you asking questions that they committed a crime, you can use that. If you ask them any more questions after that point, you must advise them of their Miranda warning, their Miranda rights. But if they simply blab to you that they did it, yeah, you can use that. 238 also talks about searches. Searches are probably one of the things that police officers get sued for or lose cases for in a lot of cases. And so I want you to read that section very closely. If anybody has any questions about searches, then make sure that you let me know, and I will be happy to try to address those. Going forward in this chapter, also understand that not every case where someone gets arrested goes to trial. Sometimes we experience what we call case attrition. Attrition. And attrition is a fancy word saying that it goes away or it stops. Because not every case is a good case made by the police. Not every case deserves to be tried. Some cases deserve to simply be gotten rid of. Maybe the person didn't really have a criminal record. Maybe it was it's a misunderstanding. For whatever reason, sometimes we just need to get rid of cases, and the way that we do that is something called a nolle prosequi. NOLLE-PROSEQUI. It's on page 242 in your textbook. And what nolle prosequi really means is we will not go forward with this case at this time. And that is an option that the prosecutor has on any criminal case. He can go before the judge and say, Judge, we're going to nolle this case. And what that means is we're just not going to go forward with it. That does not preclude that defendant from being from that case being brought back up and used against them later. It's not a dismissal. It's simply saying, we're just not going to prosecute you right now for it. The statute of limitations would apply from my experience. The statute of limitations would apply, so they basically have until the statute of limitations runs out in order to bring that case back up and use it against you. In many cases, we will nolly a case for somebody that has no criminal record with the idea that it will stay on the court docket for 6 months or a year, and if you get in trouble again within that time period, we can use that previous case as well. If you don't, then the case ends up getting dismissed and it just goes away. So that's one way that we get rid of what I would consider to be bad cases made by the court, or in some instances, cases the courts just really don't need to be involved in whatever the issue was. Going further in this chapter, make sure you read the section about the wedding cake model in 245 about celebrated cases. I think one of your discussion questions this week is about that. And also make sure that you are familiar with the 3 levels of crimes. We have infractions, misdemeanors, and felonies. An infraction is typically a very less serious crime in which no arrest usually occurs, that maybe you just get a ticket and you get a fine. A misdemeanor is a more serious crime than an infraction, but less serious than a felony. Example of an infraction might be a speeding ticket. Example of a misdemeanor might be a small theft, or a possession of drugs, or DUI. Examples of a felony would be murder, rape, robbery, your typical violent crime. So make sure that you read that section as well. All right, guys, that's it for the integrity lecture for today. Hope that helps you understand the trial court chapter a little bit better. And remember, if you have any questions or problems, please reach out. I'll be happy to help you. I will be trying to get grading for the last couple of weeks done, the last part of this week, first part of next week, and I will also be responding in your discussion postings for last week, today and tomorrow. Have a good week, guys. We'll talk to you soon. Bye-bye.